Hi, everyone. Welcome to the Nieves Law Firm Live. I am Navi, and I'm here today with Paul. We're going to be discussing Miranda rights and when you're giving your Miranda rights and what Miranda rights actually are. And we were discussing earlier, and Miranda rights actually started from a Supreme Court case in 1966, Miranda versus Arizona. And it was to make sure that if you're in police custody, you know what your rights are, and you can take it from here, Paul.
And so the key question there that Navi just mentioned was custody. Everybody always says, I didn't get my Miranda rights read to me, therefore I can win the case because the cops asked me some questions. And the short answer is no. You can be questioned by police without having your Miranda rights read. You can actually, if you want to choose not to answer those questions. Miranda is triggered, or Miranda must be given when you are in custody, meaning you're not free to leave. You don't have to be handcuffed, but you have to be in police custody where they either say to you, you can't go anywhere, or it's pretty clear from the circumstances, you're in a room at the police station and the door is closed and there's 3 cops at the door, you're in custody, and they seek to question you or interrogate you about things that, if you answer, could potentially incriminate yourself. So many, many times the police ask you questions without Miranda rights having been read to you, and it's perfectly fine. That's because you're not in custody, or they're not looking to ask questions to make you incriminate yourself. The classic example is DUIs. You get pulled over for driving under the influence or suspicion of driving under the influence, and the first thing the police officers will say to you is, have you been drinking tonight? And obviously, if you answer that question, it could potentially be used against you later on. Shouldn't I have my Miranda rights read? The answer is no. They're doing basically kind of preliminary investigation questions. They want to see what they have. And even if you say, yes, I have, they still have to do other things. They have to get other kinds of proof that you are under the influence. Because remember, it's not against the law to drink and drive. It's against the law to either have enough alcohol in your system that's a certain level, 0.08 or higher, or have alcohol in your system that's affecting your driving. But if you're driving perfectly fine and your blood alcohol is under 0.08 and you get pulled over for something else, that's fine. But they're going to ask you a question, hey, have you been drinking? They may even ask follow-up questions. How much? Where are you coming from? These things may be used against you later in the case, but you're not in custody, number one, and you're actually free to not answer those questions. Most people don't realize this, but when they're asking you questions and you're not in custody, you don't have to answer them. And if you are in custody and they've read Miranda rights, you obviously don't have to answer those as well. You can invoke your Miranda rights. But sometimes they're asking questions because the situation is fluid. It's ongoing. It's an emergency. Police officers get a call about a fight in a house. And you're in the house, other people in the house, the police officers arrive, and you're coming out of the house. They can stop you and say, what's going on? And you can say, oh, nothing, I was just leaving. And they can say, were you in there? What's happening? They're asking questions to assess the situation. Some of your answers may later be used against you, but at that moment that they're asking you those questions, they're not doing it when you're in custody, and they're not doing it to get incriminating evidence. They're doing it to assess, what do we got here? You know, maybe we'll let this person who's leaving the house go if he says, I'm the UPS guy just dropping off a package. Or maybe we'll keep him if we think he's involved in this call, the reason that we got the call. And so when you're in custody and they're asking you questions, yep, they got to read you Miranda. And if they don't, nothing you say in those questions can be used against you. And I've had cases, I think everybody here at the firm has had cases where officers have questioned somebody without reading Miranda, and then later on the DA wants to use those answers in the case, and chief can't do it. It'll get thrown out, and any information that the officers learned, if you answer a question that the officers ask you and they didn't read you Miranda, and they should have read you Miranda, if one of your answers leads them to take some other steps, investigation, and they find something based on one of your answers, that evidence also gets suppressed. So if the police screw up or get the Miranda rights wrong and question you without Miranda, or they continue to question you when you invoke Miranda, not only does what comes out of your mouth get suppressed, meaning can't be used against you in the case, but most likely any evidence that they gathered after your answer, based on your answer, will also get suppressed. So it's definitely something that your attorneys are going to be looking for whenever you've been questioned by police. And I think every attorney here has also had this situation where the clients come to us very excited. We're going to beat this case. I was questioned. I was in police custody. They didn't read me my Miranda rights. And it may very well be that you actually weren't in custody. You can actually be, you can have an officer stop you on the sidewalk and say something like, hey, can I ask you some questions? And you may think, based on how you're raised, kind of deference to authority, deference to police officers, well, he says, can I ask you some questions? So I guess I have to follow that order, right? And therefore I'm in custody. Well, not really. Believe it or not, if an officer says to you, hey, can I ask you some questions? You actually have the right to say, nope, and keep walking.
Yeah, a lot of people don't know that.
Sure, they can, if they try to stop you, put their hands on you and say, hold on a second, I want to ask you some questions. Well, now we're getting into custody waters, perhaps, right? And then they better read you the Miranda rights. So it is, I don't want to say it's straightforward. It's not completely straightforward, but for the most part, officers know that they can question you in many circumstances without reading Miranda because they're doing kind of preliminary investigations. But when they start to think, all right, this is the suspect, this is somebody we think we're going to be making an arrest or think this is probably the person who did this, and they start acting like and taking steps to put you in custody, they got to read your Miranda rights before they question you. And I guess the final point may be that if they want to question you, but they decide not to, they can put you in custody. If they're not going to question you, they don't have to read you Miranda. And if in the course of you being in custody, you start saying things because you're bored, you're sitting there, you're handcuffed, you're sitting on a bench, there's officers at a desk filling out some paperwork, and you start spouting off. Well, yeah, you're in custody, but they're not questioning you. So if you volunteer stuff, doesn't matter that they didn't read you Miranda. And so perhaps the moral of the story is the safest course of action when you're being questioned by law enforcement is to not answer. And there's not going to be any problem because there's nothing they got from you that can be used against you.
So it's just easier to stay quiet.
Yes.
Is what you're saying.
There's kind of a joke amongst a lot of folks in the practice of criminal defense law, that there's this right out there. You have the right to remain silent and, by gosh, use it, right? It's one of those great precious rights that we have. And I understand folks who want to tell law enforcement that I did nothing wrong and here's why. But, when the situation is in its infancy and law enforcement's on scene, it may not be so wise to just start talking and answering questions until they read you Miranda or place you in custody.
And if you're stopped by a police officer and they're questioning you, are you allowed to stop them and say, hey, read me my Miranda rights? Or I'm not going to say anything?
The answer is you can say that if you want. You can tell the officer, I want you to read me my Miranda rights. And the answer is they don't have to do it if we're not in Miranda waters yet. We're not in custody. We're not being interrogated. If they read you Miranda rights, and I'm getting buzzed here, and I'm waiting on a jury verdict, I'm going to have to duck out. It is the court. I'll ignore it. I'll call them right back. But if you are in custody and they want to question you and they've read Miranda, so all the boxes are checked, everything's done right. If you don't want to answer those questions, you can either stay silent or better yet, you can say, you know what, I'm going to exercise my right to stay silent. I'm going to exercise my right to consult with an attorney before answering any more questions. Because maybe for a separate discussion, we can talk more about what the Miranda rights are, but I assume everybody knows from TV and movies generally, right to stay quiet, right not to, or anything you do say can be used against you, but very importantly, right to speak with a lawyer before and during any questioning. And so when you're not sure, say, I'm going to elect to stay silent, officer, and I'd like to consult with a lawyer.
Well, that's our time. The ringer's on, and thanks for joining us on the Nieves Law Firm Live, and stay tuned for other episodes coming up.
Great. So long.